My lady today, my ladyship will hear Mr. Musemango as well as Mr. Mobo. During the episode.
Good morning, my lady. Yes, please, my lady. My lady, I will make our submission about the entrenched culture of lying about the true facts whenever there are deaths and there are incidents which are involving, in particular, police officers during the apartheid era. Yes. We are submitting, my lady, that the apartheid was institutionalized and legal profession as well as its professional organizations became complicit in construction and implementation of an apartheid. Law was a primary tool used to give effect to apartheid at that particular time. My lady, in many cases where people who were freedom fighters died, Inquest held, magistrates arrived at a decision which were actually not satisfying the people that had interest. In the case before the court, my lady, and the evidence which was before the court in 1967 inquest was never interrogated by any of the role players in court. Prosecutor that was in court. The role of the prosecutor, my lady, was actually briefly explained by my colleague, Advocate Twen. However, the evidence that was presented before the court, nature of injuries which was sustained by Chief, as reported in the post-mortem report, were never interrogated as to why, if the Chief was hit by the train but is not injured, or is not injured in the way he's supposed to be injured. We had the evidence from the witnesses that at that time there were a number of train accidents that were happening and people would be injured seriously, both torn apart, and a lot of people dying on the scene when they started the accident. In this case, that was not the case, however, it was not interrogated. Presiding officer, magistrates were appointed by the Department of Justice in terms of Magistrate Court Act of 1944 at that time. Many of them were appointed from the prosecution side, Mariti. and they were carrying out the instructions from the Department of Justice. We saw that in this case, in the evidence that is presented before the court, my lady, in particular, a response by the magistrate holding inquest in this matter, indicating that the inquest will be held before the magistrate Boswell, and he will make a finding that the cause of accident was the train, as it is indicated by the district surgeon. It was before the inquest, or before he listened to the evidence presented before him in court, viva voce and documentary. However, he had a decision already at that particular time. That indicates the extent in which stakeholders in the 1967 inquest, I mean, their conduct in that particular inquest, to say they were not actually dealing with the facts, but they were just perpetuating the apartheid, which was institutionalized at that particular time.
The memorandum that was titled Secret, and it was forwarded to the officials in Pretoria. Because to be held, and the family will not be happy with the result.
Correct, my lady. The Boswell letter, which is in 795, dated 11th of September 1967.
And the inquest was after the hearing.
On the 19th of September. The role of district sergeant as well. District sergeant as well, my lady, of great importance, and they played a huge role in ensuring that those that are not all responsible for anything they did, torturing, killing, assaulting of those who were fighting apartheid at that particular time.
With particular reference to Chief Albert Luthuli.
In particular, yes, my lady. Despite generalizing the issue, but in particular in this case, the doctor that examined Chief did not record some of the injuries, wherein the other doctor recorded some injuries. It was not only by mistake that was happening, but it was intentional. They were not carrying out their duty as an expected standard. The department as such, Department of Health, my lady, was one of the instruments used in the apartheid. It was also institutionalized to carry out the apartheid, because a lot of people were ending up in the hospital after they've been tortured, assaulted, injured by the police at that particular time. They were fighting against anybody who was a liberation fighter or activist. Your Worship, this is in a number, my lady, this is in a number of cases that happened. The case like Griffiths and China. The planning of that case indicates the planning of the prisoners when they were wanted to commit the offense. The manner in which that the planning was done in that case, it will appear a robbery.
Isn't there an inquest pending in the grand?
No, I'm talking about the old inquest and other proceedings, but there is inquest that is pending recently. But
Yes.
I'm not talking about what is happening in that inquest, but
I
the old
would prefer
inquest.
that we leave that to the judge that will be presiding over the inquest. Let us not preempt his finding, that let's leave the taken as well as well.
Escort business, my lady. The case of Hussein Hafiz
Yes.
was arrested, assaulted, and tortured severely. And then it was reported that he hanged himself. The first inquest, nobody was responsible for his death, despite having injuries, despite visible injuries, and later on, the inquest was reopened, and it was clear that he was actually assaulted, and police officers were responsible for the death of Hussein Hafiz. Cases like that of Timol, whom was arrested and reported that he committed suicide by jumping from the 10th floor in the John Foster police station. Inquest, or rather, the police officers did a lot of cover-up in that particular case. Like in the present case of Chief Luthuli. There's a lot of cover-up that was done in this particular case. And in Timor first inquest, nobody was responsible till very late. That police officers that were there testified as to how he was assaulted. Cases like Haron, Imam Haron was arrested, assaulted, tortured, and when he died, it was said that he just fell on the stairs as he was walking down the stairs. He fell and he injured. He died. It was only later on that it was disclosed that he was actually tortured and assaulted. TRC reports are dealing at length with the way in which role players were behaving during the apartheid, with the period of review of the TRC, which was from 1960 to 1994. And there was a lot of evidence available on the TRC regarding doctors, prosecutors, magistrates, and other role players in Malaysia. When they dealt in particular with magistrates, this was one of their findings, that there were several inquests where nobody was found responsible for the inquest. For the death
of the victim involved.
Yes, my lady. And they made an example of the inquest of the Pali when he was found hanging in the cell. The inquest of Siphomo's COSAS leader, who was arrested and found dead in few hours. They were just in this Malay, I'm just indicating how the magistrate were behaving at that particular time, not looking into the matter, based on the matter. And one of the example which also TRC highlighted about doctors that were examining patients in particular when they were arrested. TRC made an example, the following example, my lady. The evidence available to the commission suggests that district surgeons were not directly involved in committing gross violation of human rights during the period under review. The period under review, my lady, was 1960 to 1994. And the case we are dealing with is from 1967. It includes this case, even though it is not specifically referring to this, but it includes this case by mere fact that the period is included. Their most common offense was a failure to carry out their duties within international acceptable guidelines of medical ethics and human rights. We will submit in this case, my lady, that doctors that examine Chief did not carry out their duties properly in terms of international guidelines or international accepted guidelines of medical ethics. Referring to a better hospital that could have treated Chief Luthuli better is one of the reasons why we are saying they did not carry out their duties properly. Sourcing the doctor who was called to come to the hospital without anything to use in healing the patient, Chief Luthuli. It's one of the reasons we are saying that they did not carry out their duties properly. My lady, the evidence adduced by all witnesses before this court suggests that Chief was not hit by the train, but he was assaulted. A proper planning was done to carry out the plan which apartheid police officers had planned. People that killed Chief Luthuli, my lady, were in the train. The railway itself was institutionalized, was institutionalized to be carrying out apartheid activities in no way that if people that assaulted Chief Luthuli were not officers, in no way that the driver and other occupant of the train were not aware that Luthuli was going to be killed on that particular day. We had the evidence before this court that there is a boy who was riding a bike on that particular day who saw a train stationary and white people using shovel assaulting Chief Luthuli.
We have found the name of the boy by virtue of
yes, Mbeni. The name of the boy is Mbeni. Yes,
Yeah.
So this court is having that evidence to say the shovel was used. And it's common cause that the shovel was used also in the locomotive at that particular stage to load coals on the bow. So we are saying even railway was involved. My lady, lastly, in 1962, the former president of South Africa, Nelson Mandela, was accused in one matter, and he had to say the following about the law in the country at that particular time. Open quote. I would say that the whole life of any thinking African in this country is driven continuously to a conflict between his conscience on the other hand and the law on the other hand. The law as it applies, the law as it has been developed over a long period of history, and especially the law as it is written by the nationalist government, is a law which in our view is immoral, unjust, and intolerable. Our conscience dictates that we must protest against it, that we must oppose it, and that we must attempt to alter it. As I'm submitting, my lady, that the law was a tool that was used in apartheid. It's not something which is actually one infer from nowhere, but from the facts. Even at that particular 1962, this was already an issue of law that needs to be changed, which actually apartheid was using it to fulfill their need. That is our submission, my submission.
Thank you. Thank you, Mr.
Yes, my lady. My lady, maybe starting from where my colleague ended with the quote from the late statesman, what I propose to deal with is an international perspective, and then I will contrast that with the facts in this matter. And I will also just make a little bit of reference on the approach that is expected of this court in analyzing the evidence in proceedings of this nature. It was in the year 1966, just the year before Luthuli was brutally killed, that the United Nations organization, through its General Assembly in its 21st session, passed a resolution 2202A, which was titled "The Policies of Apartheid of the Government of the Republic of South Africa." I've got a copy that I will hand to my lady of the specific resolution portion that I'm referring to. It is the resolution was titled "The Policies of Apartheid of the Government of the Republic of South Africa." It's resolution 2202 of the United Nations General Assembly, and this resolution was passed or was reached on the 16th of December 1966. In this resolution, why it is important to mention it and to simply bear it in mind in the assessment of the evidence is that as at that time, what it portrays is that the United Nations General Assembly had been actually grappling with the problem of apartheid in South Africa for a while before that resolution. And in that resolution, then they came to a point where they said, we are expressly condemning what is happening in South Africa. The policies of the government of apartheid amount to what they termed at the time a crime against humanity. And when they did this condemnation, they then were not saying it is legally criminalized. They were saying what is happening is a crime. Why do you continue to do this? And reading from that resolution, the court will notice that it was preceded by other engagements and resolutions prior to that in the previous years, coming from the 1950s and the early 60s, wherein the assembly had continuously been condemning the conduct of the South African government. What then followed that, now the assembly saying expressly that this is actually a crime against humanity, this policy of apartheid in South Africa. And they begged in that resolution, amongst others, they said, amongst others, they implored other member states at the time to also condemn the policy of apartheid in unison, to also monitor and try to impose sanctions which were of an economic nature and social nature to South Africa, to try and fight and try to compel the government of South Africa to change from its stance and its implementation of the apartheid policies. How they viewed these apartheid policies was that they were to create, and they had a potential, and already at that time they were creating some instability. Within South Africa, the instability was quite palpable, and internationally, these are the potential of creating instability. Chief Luthuli was subjected to those, to that crime against humanity. It was their view then, and it was then in 1973 when the United Nations again, in 1973, declares it a crime against humanity with a proper definition in compliance with the principles of formation of criminal offenses, the nullum crimen sine lex principles that the court would know about. And this is expressed in an article which is obtainable from the United Nations Organization's website under the United Nations Audiovisual Library of International Law, which was penned by a professor from South Africa, Professor John Dugan. I've got a copy, I've made an extra copy of that article for the court. And in this article, Professor John Dugan indicates that in 1973, then apartheid was then officially criminalized at international level, and it became a crime. What did this crime, how was this crime composed? In other words, what constituted this crime? And Article 2 of the resolution that made it a crime then said the following, and I'm quoting from the article of Professor John Dugan. He says, I open quote, Article 2 lists acts falling within the definition of a crime of apartheid as including murder, torture, inhuman treatment and arbitrary arrests of members of a racial group, deliberate imposition of a racial living conditions calculated to cause it physical destruction, legislative measures that discriminate in the political, social, economic, and cultural fields, measures that divide the population along racial lines by creating of separate residential areas for racial groups, the prohibition of interracial marriages, and lastly, the prosecution or persecution of the persons opposed to apartheid. Now, that last, although the rest that comes before that are what was happening during the life of Chief Albert Luthuli. Those who were opposed to the apartheid policy were persecuted openly by the government of the day. Chief Albert Luthuli's circumstances and his death should be understood in the light of those living conditions. It is for that reason that I'm raising it. We have foreshadowed it in our written submissions at paragraph 19 of our of our written submissions. We have foreshadowed it, and we have referred there the court to your ladyship to a case of a recent case of Mafala Pizza, the state versus Mafala Pizza, which was in Gauteng, in Johannesburg. The judgment which was handed down earlier this year on the 14th of April, the day we started this hearing. In that judgment, the court was dealing with a question of customary international law and whether people could be charged with a crime of customary or contravention of customary international law. And that is what the case dealt with. However, what is important for my lady is that it became clear from that judgment and from what I've indicated that since apartheid as a crime was criminalized in 1973 by the United Nations Organization, then it would not, as a crime, fall formally within the period when Chief Albert Luthuli was killed in 1967. But the circumstances under which he was subjected are relevant for purposes, as the evidence has shown, are quite relevant. And that declaration of apartheid as a crime was, and it is referred to in the case that I've referred to, which is readily available on SAFLI, the Convention on the Suppression of and Punishment of a Crime of Apartheid of 1973. That is the United Nations Convention. It's colloquially known as the Apartheid Convention. And at the time it was, and to this day, it was known as the Apartheid Convention, which referred specifically to the South African government. Because even the understanding and the writings after that, it was always referred to as a matter or a circumstance that prevailed in South Africa. It was to that extent that what South Africa was doing to the likes of Chief Albert Luthuli had attracted international condemnation. So I raised that issue on that basis, the issue of this international law. My lady, in the case of Timor, that my colleague has referred you to, Motley J, that case is referred to also in our written submission and it's readily available on Submit. It's a reopened inquest into the death of Ahmed Is of Timor. At paragraph 27 of that judgment about the how or what is expected of your ladyship in assessing the evidence that is presented before you in this case, Motley J says the following, and I quote, he says, the reopened inquest requires a consideration of the entire evidence considered by the initial inquest, as well as the evidence that was available at the time of death, which for one or other reason was not or could not be considered during the initial inquest proceedings and has become available, close quotation. Now, that sums up in our view the approach that the court has to take in assessing the evidence. What is before you, in short, with reference to the facts, is that the inquest record of 1967 demonstrates that at the time when that inquest was conducted, there were witnesses who could testify about the personal circumstances of Chief Albert Luthuli. Those witnesses are Mrs. Veli Luthuli, who was here, Dr. Albertina Luthuli, who was here, Mr. Numan, who testified here, and other witnesses who have testified before you. That evidence was available. For some or other reason, correct, the clerk from, yes, Mr. Manju, he was available at the time. And what he told you here is something that was available then, which was never considered by the court. Of course, understandably, as the court engaged with my colleague yesterday, what is clear is that it would have been, or one can assume safely, that it would have been difficult for certain witnesses with information relevant to what had happened to come forward at the time. Mr. Numalo himself, when he testified before you here, I think the court observed in his demeanor and what he said, this is over half a century ago that this incident took place. Mr. Numalo was still afraid to mention the name Chief Albert Luthuli because of the inculcated repercussions of the time in mentioning it. What you've heard also is that from Mr. Mdlete, who testified before you, is that Mr. Mnyandu, the one who told him about his younger brother, was afraid even to mention the issue of police, to mention the police, to go to the police station. And Mr. Mnyandu died in 2018 from the evidence you've heard. And this is 30 years and over from democracy, when South Africa became a democracy. And that is how deep the sense of fear was inculcated to some of the people to even come forward and say a word about these things.
What do you say of Mrs. Mele, the 84, she yeah.
Yes,
The recent, the last exhibit, FF and FF.
correct. Mrs. Nwele as well. Of course, she is old now, and as the court would have heard from the affidavit itself, that even around her, the family is uncomfortable with her coming forward, let alone that she is sickly. She is a sick lady, an old lady. The family is uncomfortable. Even the mention of this long ago is still uncomfortable for many people.
They still fear victimization.
They still fear victimization even now. You would recall, my lady, that when you were engaging with my colleague yesterday, that from the statement of Mrs. Nokanya Luthuli, the wife of Chief Albert Luthuli, there was a sentence included right at the end of that statement to say, as the family, if I quote, as the family we accept, this was a pure accident. And Mrs. Luthuli was never called in that inquest. It was during the time of mourning. And understanding that it would not have been true, because the feeling of the family during the time when the news broke was expressed by Dr. Luthuli. They never believed that it was an accident. So it could not have been that Mrs. Luthuli would have said that. But that was never interrogated anyway. But the fear also, on the issue of the fear, I think we deal with it extensively in our written submissions. One questions how a gentleman called Trilling would not have been afraid. This is the conduct of Trilling, would not have been afraid to even go to an extent of going to the Luthuli house, having heard that Luthuli has been involved in an accident. Sit there for 2 hours and then go back and go to hospital for that. Who was he who was not afraid at the time to be associated with the Luthuli? We've heard that people were victimized for that association. Who was this gentleman? It speaks to the tentacles of the security branch, how deep they were. It appears that he may well have been, to a certain extent, working with them.
Mr. No, I know that this would be like a very speculative.
Yes.
He is sitting there at the Luthuli homestead, having discovered, having ascertained that there is nobody.
Yes.
Wouldn't he be, perhaps, can we come to an inference that he was guarding the home so that to see who comes in there as a possible witness to what happened? I know we can draw an inference, although that is not the only inference. I think
correct.
The junior referred us to the cardinal rules.
Yes,
of
yes,
logic.
yes.
So, because of the standard of the test applicable here,
Yeah.
I'm sure we are allowed to draw such inferences, which would not be the sole inferences that we can draw.
Correct. Correct.
Because I've been wondering in my mind as to, if a person says I'm a grandchild, where of course we don't know how old he was to qualify as a grandchild, but to qualify himself as a grandchild, so important this grandchild was that he is the one that identified the body as the head of Chief Luthuli. Because those are normally done by like brothers, mothers, and very close family.
Close family members. Yes.
So for him to sit there for 2 hours, and the timing is such that by Chief Luthuli, according to the records, died around 2:30.
Yes.
So although the 2 o'clock is an estimate, so we do not know whether he only left after somebody said, now you can leave.
Yes.
Everything is safe.
Yeah.
What do you say of this?
He's
Just if we unbundle his behavior from the time he says he saw Luthuli at 6:30 waiting for lift, and yet Mrs. Nobukanya, his affidavit says Luthuli left at 8:30. To the time when he goes to the Luthuli homestead. With this emergency news, but then decide to relax and sleep there.
Yes.
Until coincidentally around the time of death of Luthuli.
Then he has to go.
Maybe you will help me solve the kind of behavior. Can we draw any inferences from that?
It's my lady. We've grappled with his behavior alone for a while. Because when he leaves in about 2 hours, Luthuli is dying around the time when he leaves, actually, when he leaves the home. Who is to say that he was not comforted to be told that, no, he is now dead, you can come. But even with that, it is too much of a coincidence that he sees him, he says he sees him in the morning. It describes exactly what he was wearing on the day. And contrasting that with his conduct. But having seen him, he says, no, later then I'm sitting at the bus, bus terminal where he was working. And then somebody from the hospital come to report to him what has happened. Why would that happen? If he was told, why, if he knows the family of Luthuli or claims to be a grandson as he claimed in that statement, would he not, as the first common sense dictates, call Mrs. Luthuli or call the family of Luthuli to say, this is what is happening. Please know that this is the situation. Remember, Mrs. Luthuli is in Durban, and a call was received in Durban to say he has been involved in an accident. He will be brought to King Edward Hospital. Now, during that year or those years, then we know for a fact that telephone calls were there. Why couldn't Pili phone the members of the family if he is so close to them? Wouldn't Pili have been one of the people who were monitoring Chief Albert Luthuli throughout, or used to do that? His conduct is quite suspect. I don't want to elevate it to an extent of saying he was indeed following Luthuli, but his conduct is very suspect. Hence his statement leaves a lot to be desired.
Contradicted. by available evidence.
Correct.
As to the time,
Yes.
and we know that the Romanian left the home
Yes.
to the hospital. If Queen was gone to the Luthuli homestead to deliver the message that Luthuli is in hospital and injured, he seems to know that he's injured by train.
Yes.
Wouldn't he then, after finding that there's nobody at home, go back to the hospital? Because he says he heard from the missing aide that Luthuli is in hospital. Wouldn't logic take that if he finds nobody at home, then he rushes back to hospital
To hospital.
instead of just sitting?
Instead of sitting at home. That is the conduct that is very strange of this character. In any way.
Does it amount to show that Chief Luthuli was under constant surveillance, even when he was lying in hospital and dying? He was still surveillance.
That is the submission exactly. We condemned this in our written submission that indeed Luthuli was under constant surveillance, and that piece of evidence from Trini, it may well have been intended at the time. They may have thought obtaining his statement would be sort of innocent and neutral, but the truth is a strange way of showing up. And as we analyzed now with the other evidence, it is clear that Luthuli was under constant surveillance and was surveilled even during that day, particularly during his movement. Yes, that is correct. There is no reason why a nurse or an official from the hospital, at least it doesn't appear from the statement, why that official would have run to the bus rank to tell Trini about what happened. Remember, the Luthuli family is known. During that time, the Luthuli family is known. And I would venture to suggest even that it is known that one of Luthuli's daughters is a doctor, a medical doctor. That is why one who is at a certain hospital in Durban is called to inform them. Makot Zulu Hospital, yes. That is in Durban.
Yes.
Yes. It is called. So why would somebody be running around looking for this character at the bus stop to tell him what had happened? It's a strange coincidence. And if you look at it with other evidence, it is even stranger and suspect. One smells a rat, as people would say. The conduct of the Luthuli, or the part of the evidence where it was indicated by Dr. Nzele that Luthuli had injuries which are in conformity with assault, some of which defense injuries. Now,
rather than a train accident.
Rather than a train accident. Now, look.
I was just thinking to myself that here comes a train, whether it whistles or not.
Yes.
Can you really defend yourself against the train?
My lady, I think there is quite a plethora of case law with regard to use of common sense.
Yes, common sense.
And common sense dispels that notion out the window.
I'm sure you can defend yourself against a bicycle. Like
Yeah.
the one that was being ridden by the
Yes,
yeah,
Yes.
the dark bicycle, but the train.
but the train, it's beyond.
At 40 kilometers an hour.
It is. Common sense doesn't allow it.
So
Even
Dr.
analysis
Dr. Nzele's evidence
So-
about defense
is
the
corrupt.
circumstances of this matter.
Yes.
You say that the person was defending himself against a person or person associated.
It would appear corroborated by the fact that if you look at Nzele's evidence, defense wounds and all of that, and then take the evidence that we've heard of Mbegu, who unawares then sees this incident of assault taking place on Chief Albert Luthuli. And when he sees this assault, he is spotted, he is chased, he runs in his bicycle. But then that is not the end of it. He is actually pursued. Whether on the same day or a few days later, but at least he is pursued until he is found.
If I'm not mistaken, Roger said plus minus 2 days.
2 days, yes. So he is pursued and found. And not only found, later in international law, in what is called the Rome Statute, which is now part of our law in South Africa as well, they have defined what is enforced disappearance. An enforced disappearance, they have defined it in the following terms, and I just want to, they define it in Article 7 of the Rome Statute of International Criminal Court. They say it is characterized by mainly 3 things. One is
Forced disappearance.
enforced, the crime of enforced disappearance. Mainly 3 things. They mention that one is deprivation of liberty against the will of an individual. That is commonly what we refer to as kidnapping. 2, involvement or acquiescence of state authorities. Now, in that part 2, who chased after Ben? We know for a fact now, at least from what we heard, that it was the police.
Either from Tongat or
Yes, correct. But even then, if it was police from Tongat police station, why would they chase him not knowing what had happened at Gledo police station? Who would have been the connection? Then it brings back the security branch to the connection of that. So involvement or acquiescence of the state. And number 3, the concealment of the fate or the whereabouts of the victim.
it would be about 8 weeks.
Yes. But the fate,
Nzele's statement that he was 4 years.
recollection of Mrs. Nzele, yes. But the concealment of the fate, what befell him, is concealed by the state. His whereabouts is never known since then. And we understand why now, at least, why the family could not talk about it, because that fear of even talking about it is what Thomas Nyandu, the Induna, even died worried about his son. And the one who died, the brother who died in 2018, died still holding it to himself, the worry about what had befallen his younger brother. So it appears then what really happened here was a situation of enforced disappearance insofar as this Nyandu boy is concerned. But for what good reason? Because of what he witnessed. There is no other connection. Because of what he witnessed happening to Chief Albert Luthuli. Then there is corroboration therefore that indeed those could definitely be defensive wounds as described by Dr. Nzela in his evidence. So Luthuli was actually assaulted. One can safely conclude. Yes.
Unless you have to.
Oh, yes, we can take it right.
Tutati kiefunje iskam se horas kubega notja. Elas pagamos
You're still the address of enforced disappearance.
Correct.
Yes. Are you still on that or will you move?
I'm now moving away from that. The reason why, just to sum up, the reason why I raised that issue of enforced disappearance and what constitutes that crime and what happened as against what happened to Nyani is for the court to understand that what happened even then, even though international community had not declared it a criminal offense that enforced disappearance, it was actually a crime against humanity. But it did amount to kidnapping at least. And at the very least, with him having been taken and disappeared like that, the assumption clearly is that he was killed, and one would safely assume that, safely be forgiven to conclude that Luthuli was actually killed. But
Can you
it's
safely use a presumption
correct.
that you are killed? It's about now 58 years ago.
Yes, that is correct. Of course, Bemu's matter is not before you for inquiring on it. It is before you because it explains certain happenings in the death of Chief Albert Luthuli, and my lady would see that in the crafting of the order that we seek. Towards the end of our written submissions, I think from paragraph 283 to the end, we've crafted quite clearly what we will be seeking the court or imploring the court to direct insofar as Bemu is concerned, that at least his matter deserves to be investigated as it has emerged before you. And remembering that how it emerged was coincidental.
Yes.
From Ledger himself, yes, he says, no, I was busy doing renovations, and then I speak to this person and tell him about what I was told, not knowing that he is going to tell. He actually appeared to be fuming that the secrets he was talking about ended up being revealed,
Yes.
not realizing the importance of that information that he had to the determination.
To be the last person. I know ZP also said something, but not as directly pointed
As in being, yes.
we were gone there to deliver
Yes.
the letter concerning the land claims
Yes.
issue.
Yes.
Time,
Correct.
only to find that Luthuli is not at home, and he was directed to the fields. When we came there, as he was passing on en route to the fields,
Yes.
uh,
He
then he saw
witnesses.
this.
Yes, he witnesses what was happening. So we deal with it in terms of what we seek in the order towards the end of our written submission, and I think that suffices insofar as that issue is concerned. My lady, when I was talking about the approach as outlined in the Timol case by Mondlane, the court will notice that in that approach, if you apply that approach and you analyze the evidence of the initial inquest in 1967, you would realize that the magistrate then, Mr. Boswell, simply accepted the ipse dixit of the likes of Lategan about what happened. And that is very strange, why there wasn't actually a probing of this. But again, if one understands the circumstances around the conduct of that inquest, one can then see the relationship between the conduct of the inquest itself and the secret circular that my lady was talking about. Lategan was unrepresented in that initial inquest. Lategan claimed to have driven the train that hit Chief Albert Luthuli, and his employer and himself saw it fit that he should appear there in person unrepresented to protect the rights not only of himself, but the rights of the employer. What was that assurance that was so daring that he could be there unrepresented? It may well, one would be speculating to say maybe that assurance came from that circular, which we do not know about, but it is quite suspect. And when my lady engaged with Advocate Dunya on the standard of proof, I think we deal with it also in the, if I may locate the paragraphs, we've dedicated quite towards the beginning of our written submissions. Yes, towards the beginning, we've dedicated quite a couple of paragraphs on dealing with that, where we contrast the standard of proof in criminal matters, which is not applicable here, and we go to even an extent of saying, we venture to suggest that it is not the standard that is applicable in civil matters, which is on a balance of probabilities, because the act itself, what it requires of you is simply to have an opinion. If you are of the opinion that this is what happened, then you are entitled to, and to make that order. In our view, then, that is much lighter, even lighter than that civil standard, the standard that you have to employ. Yeah.
The expose in paragraph 19 onwards.
Yes, actually, yes, I found it. It's paragraph 19. We deal with that, paragraph 19 to, I think it's paragraph 24. We deal with that, and in particular, in paragraph 23, when we refer specifically to section 16(2)(d) of the Inquest Act, we went into some detail to explain what is required in terms of the standard of proof that is required of you in analyzing and to be able to make the finding that is required in terms of the Inquest Act. That is because the inquest itself, by its nature, as Advocate Dunya referred, is an investigative process which is regulated by the Act, and it is driven by the presiding officer. It is the fact that it is an investigation. It doesn't find determinatively, in other words, it's not the end, because it's an investigation. So that is why it is correct in our view that if you have an opinion, if in your opinion you are satisfied that this person is responsible, then you are entitled to make that finding a positive finding as required. But we've sort of outlined the order itself towards the end, how the order we propose it should look like. I think those are my submissions. There is one issue that I just highlighted, which was about the fear, but we deal with it extensively in our written heads, the fear by witnesses to come forward during that time, and we explain it in detail in our written submissions. And at some stage, there is a comparison that Advocate Msimango has drawn to the court's attention, and I wish to draw it a little bit differently insofar as the importance of personal circumstances when you are investigating the circumstances of a death of other than natural causes, as is the case here. And you would find that in the Harun case, which was in the Cape, reopened inquest into the death of Imam Harun, which was in the Cape. His religious beliefs, personal circumstances of the community where he came from became very important in determining the probability or not of him having committed suicide. And this became the case in this division in the Hafeji as well. It played a very major role, those personal circumstances in those cases. So is the case, the first one of Timor. Those played a major role. And we submit that in this particular case, these circumstances, these personal circumstances of Chief Albert Luthuli should play that role, and having a look at them holistically, the issue of this train accident is rendered improbable by understanding who he was. In closing, my lady, I wish to say or to quote coincidentally a journalist. He is late, died in 1986. An American journalist, Sidney J. Harris, about the history. And I'm contrasting this to the purpose of the inquest, because why inquests are important to hold is because no death should occur, and we should never know how it occurred. We should be able to investigate it so that we know what happened, and the government or those responsible in power can help to prevent it from reoccurring again. And this gentleman, he's late, he said the following in my closing, open quote, "History repeats itself, but in such a cunning disguise that we never detect the resemblance until the damage is done." It is close quotation. It is by Sidney J. Harris. Those are my submissions.
As a court business, my lady, in closing of our submissions, I wish to take this court through our prayers as contained in our written submissions. My lady, before I do that, I just wish to refer to the matter which was decided in this division, the matter of Dr. Hussein Hafeji, where your brother Nkosi presided over the reopened inquest. My lady, what was noted in the said judgment was that the reopened inquest, like the one before this honorable court, where revolutionaries have come too late for families. Reopened inquest on the circumstances that led to the death of revolutionaries came too late for the families. However, as referred to by your brother Ngosi, families never lost hope of the truth and justice. The Justice Ngosi quotes what was said, which was an appeal made by Fatima Hafeji to the Nation Commission, orating the pain and suffering which was endured by the family for decades. This is what Fatima Hafeji had to say. I quote, "I know the truth about how my son died is going to come out one day. I want to know the truth about how my boy died. I'm very heartsore, and I will not rest until I found out who the killers are. I will never believe my honest, home-loving, and caring son took his own life." My lady, this finds its relevance in this reopened inquest of Chief Albert Luthuli, and it echoes what the members of the Luthuli family said during their testimonies. My lady, having said that, because I do not intend to overburden the record, I will go straight to the prosecution's submissions, which are based and mounted on evidence that has been laid, and without necessarily repeating the evidence and or submissions that have been made by my colleagues. I will state the body of our prayers. The first prayer is that this honorable court must find and rule that the finding and the ruling of Magistrate Mr. C.I. Boswell, dated 19 September 1967 at Stanger Magistrate Court under Inquest number 76/67 is set aside. That is our first prayer, that inquest should be set aside. Those findings as well as the ruling. Furthermore, we ask of this court that in terms of section 17, capital letter A, in brackets 3, read with section 16, subsection 2 of the Inquest Act 58 of 1959, as amended, the following orders amend. One, in terms of section 16, subsection 2A, that the deceased is Albert John Mvumbi Luthuli, an African male, and the former president of the African National Congress. Two, that in terms of section 16, subsection 2B, as to the cause or likely cause of death, it is found that the deceased died as a result of fractured skull, cerebral hemorrhage, and contusion of the brain associated with assault.
But you mentioned 3 likely causes of death. They're all in the skull.
That is correct, my lady. They're all in the skull.
Head injury. Can you sum them up? There's head injury.
Correct. 3, in terms of section 16, subsection 2C, as to the date of death, it is found that the date and time of death is approximately 1400 hours, 25 minutes, that being PM, on Friday, the 21st of July, 1967. In terms of section 16, subsection 2D, as to whether the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person or persons, it is to be found as follows. That the death is attributed to cumulative acts and or omissions on the following persons and or members of the following state organs. Assault by members of the security or special branch of the South African police, acting in concert and in common purpose with employees of the South African Railway Company. But then if I may just explain a bit on this particular betrayal. My lady, my learned friends articulated how, as per evidence, the president of the African National Congress, Chief Luthuli, was under surveillance. And as we have in our written submissions, further indicated that in terms of various pieces of legislation, the Terrorism Act, Chief Albert Luthuli was subjected to restricted movement and surveillance. And my lady, as it was evident from the various exhibits handed to this court, the magistrate that had to preside over his inquest was appointed to supervise his adherence to the banning orders. And whenever he sought to move out of the jurisdiction of Stanger, even to Devon, for medical reasons, he had to submit an application to Magistrate Boswell, who would have to consult on Chief Albert Luthuli's request to be allowed to visit medical practitioners. My lady, submit, as it has been submitted, rather, we're asking that this court has to find, and there is merit. The likes of Mr. Ladekhan, whom I am to refer to later, were part of the South African Railway Company. Furthermore, my lady, as it appears on page 63 of our written submissions, we are asking of this court to find that the following persons committed the crimes or offenses of defeating the ends of justice, perjury, and being accessories after the fact to the crime of murder. Mr. Albertus Stephanus Ladekhan, Mr. Daniel Greiling, Mr. Francos, Detective Sergeant Andreas Petros Becker, Detective Sergeant Charles Baron Petros Lois. My lady, these are the prayers as we continue to ask further that Andres Pretorius, the Glencoe Station Master, Glencoe Station Master, Mr. Stein, who was the foreman of the station. My lady, I can only emphasize that we ask of this court to find that Chief Albert John Mvombe Luthuli was murdered.
Mr. Kenya, there is also, as Mr. Nwabo alluded to, the issue of Mbemu in your written submission on page 64.
Correct, my lady, and we further, I'm indebted to the court for that reminder. We are asking that the court recommends a full investigation into the circumstances of the kidnapping, forced disappearance of Mbemo Mnyango, who evidence indicates that he disappeared as a consequence of being an eyewitness into the assaults that were perpetuated against Chief Albert Luthuli. My lady, those investigations ought to be undertaken as a matter of urgency. Furthermore, my lady, we wish that the court would make comments at the list based on the evidence submitted, which spoke to the institutionalization of apartheid, how the Department of Health in this case, South African Police, and South African Railway, as well as Department of Justice, appear to have colluded. If, my lady, I were not a prosecutor that I am, as much as Ms. Schwene in her address is stated unambiguously the duty of a prosecutor towards court, I would endeavor to ask this court not merely to have a look at what the presiding magistrate at the 1967 inquest proceedings, but also to look at the various court officials and ask itself, how the narrative, as it was put before court, of the death of Chief Albert Luthuli passed through the eyes of the prosecution without questioning it, without interrogating, at the least, the post-mortem, and just oppose it to facts about train accidents and or victims of train accidents. How could it have been that those inquest proceedings appear as they do to be a tick box exercise? My lady, those are our prayers. Unless the court wants me to deal with a specific issue that I might have overlooked or overlooked by any of my colleagues.
I'm not complaining, but I'm echoing my gratitude that you said more than what the written submissions are. And this court, the ball is now in my court to kick in the box of the US president. You are going to kick it on the 30th of October or later?
My lady, if I were, I would have asked that it be killed yesterday. However, because my lady yesterday has gone past, I would ask my ladyship to hand down her judgment on the 30th of October at this court at the time to be appointed by the leadership.
Mr. Noble seems to want to say something to you.
No, my lady, no, yes.
What day of the week?
It will be on a Thursday. It will be on a Thursday, my lady.
Yes, because on Fridays normally they use this court a lot. So this day is better.
Yes, the court pleases, my lady.
Thank you very much, Mr. Junior. Thank you, Ms. Trene. Thank you, Mr. Msimani. Thank you, Ms. Bede. This proceeding stands again to be taken over to for judgment.
Ikade lizokhipha isinqumo sayo kulolu daba ngolwesine lamhla ka-30 October ngehora leshumi ekuseni. Cela siphakame.